Seems like everyone is here. We shall start now. Assalamualaikum warahmatullahi wabarakatuh and good morning to everyone. My name is Faridatul Syafiqah binti Syamuddin and I will be moderating this workshop, which is workshop 2, What to Research in Memorial Submission. Before we begin our program, please fill in the form through the link that we have provided in the chat box. Thank you. Without further ado, let's move on to our main agenda today, and please take note that the purpose of having this workshop is to introduce international law muting to FOHA students. This workshop aims to give our students an opportunity not only to know better about international law muting, but also to give them a better view on what to research in memorial submission for muting competition. Our speaker is Ms. Nur Syahmina binti Zainal Abidin. If you have any question for the speaker, you can ask during the Q&A sessions. The wonderful speaker for today is Ms. Nur Syahmina binti Zainal Abidin, IIUM student and also the president of Moods and Client Consultation Club. Before we start, it is an honor to invite Ms. Syahmina as our speaker today, since she has vast experience in multi such as novice arbitration multi competition, and her team was the champion for the competition. Other than that, she also involved in RWC NAMCO Sports Arbitration Multi Competition. Today, Ms. Syahmina will provide us about what to research in our memorial submission. Without further ado, I will give the spotlight to Ms. Syahmina. Everyone, please be ready with papers and pens. The floor is yours, Ms. Syahmina.
All right, thank you, moderator. I believe it's Faridatul, right? The one who spoke just now. Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. I bid to everyone that attend this workshop today. So first and foremost, I think I would like to thank the committee of ILSA UNISA for having me to this workshop today to share the insights and a little bit of knowledge about what to research in memorial submission, the concept, and what are the processes that is involved when it comes to memorial submission. So my name is Nur Syahmina binti Zainal Abidin. I actually prefer to be addressed as Mina. It's much more simpler and convenient that way. So I am currently in my third year, second semester in IIUM or UIA, and holding the post of the president of IIUM Moods and Client Consultation Club. So as has been introduced earlier by the sister moderator, Sister Faridatul, I believe just now, my first experience when it comes to mooting is that I have joined the NAMCO Novice Arbitration Mooting Competition, which Alhamdulillah my team managed to come up as the champion. And right after that, I joined the VIS Commercial Arbitration Moot Competition, which is the biggest mooting competition in the world, revolves on the arbitration setting. And we joined the AIAC Moot competition, and my team came up as the champion for Malaysian team. And then I joined the RWC NAMCO Sports Arbitration Mooting Competition, the SAMCO. That time I became the coach, and the team that I was coaching, Alhamdulillah, advanced up to semi-final. And previously, just like the competition that I had entered and had actually ended recently during this last April, was the VIS commercial as well. So I hope that through this competitions, I could be of help when it comes to memorial submission. So when I was first offered to become the speaker for memorial submission, and when Fatiha, one of the committee from ILSA UNISA, actually showed me the moot problem about international law, I was a bit freaked out, to be honest, because I had never had any experience joining a mooting competition on the area of law being the international law, because the one that I joined previously is all about either international commercial arbitration or sports law. That's all. These are the two moot competitions that I have ever joined lah. But when it comes to memorial submission, any kind of mooting competition, they actually share the similar pattern, the similar body. So there is not much of a substantial difference when it comes to memorial submission from one mooting competition to another mooting competition. So today I hope to share a little bit of tips and tricks, and also what are the processes that you can actually utilize when it comes to memorial submission. Okay, now I'll be sharing my slides. Okay, can I know if you guys can see my screen, the one that I'm sharing currently?
Yes, we can.
Okay, can you see it moves to another slide?
Yes.
All right, Alhamdulillah. Okay, so first let's start with memorial writing. So what is exactly memorial writing? Okay, so in my talk today, first and foremost, I would be introducing a little bit about what exactly is memorial writing, how does it work, and when you will have to do this memorial writing. And secondly, we will be looking at the content of the memorial submission, basically what are the processes involved when it comes to writing a good memorial, and why is it important to actually write a good memorial. And last but not least, we'll be looking at previous memorial, like how to see the example of a memorial submission. So we will be dissecting and analyzing the bodies of the memorials together. Okay, so first and foremost, what is a memorial submission? So basically, it is actually a written argument submitted on behalf of both the applicants and respondents, and it is also interchangeably known as a written submission. So basically, memorial submission is a written argument. It's actually an argument where you would be submitting on behalf of the parties that you are representing, whether it is the applicant or even the respondent. It is an argument, but it is in a written form. So it is also interchangeably known as written submission, or even sometimes we call it as memorial submission, depending on the types of mooting competition that you will go for. And also, how does this memorial submission actually works is that you would have to submit a written memorial on behalf of both of the parties that you are representing. So now I am actually talking about a memorial submission in the context of a mooting competition rather than the actual practice field that you will be entering once you graduate soon. So when it comes to mooting competition, when you go for any mooting competition, be it international law, commercial arbitration, sports law, human rights law, or whatever it is, when it comes to written submission, you would have to prepare the written submission for both of the parties, i.e. the applicant, claimant, plaintiff, appellant, the one that brings up the dispute, or even the respondent or defendant, the one that is responding to the dispute brought by the applicant. So for example, when you go for the international law moot competition, then you will have like counsels, okay, these two counsels. So these two counsel will be representing both the claimant, let's say claimant, and also the respondent. So first and foremost, you would have to actually prepare a written memorial on behalf of the claimant. So you write the arguments that will bring benefit to your client and also the one that will be detrimenting to your client. So that is how you write a written memorial. First, you prepare a written memorial for claimant. And secondly, you will have like a time gap after you have submitted your written memorial on behalf of the claimant. Then you will have a time gap to prepare a written memorial on behalf of the respondent. So this written memorial that you will be preparing for the respondent is actually a response to the written memorial that you have submitted for the claimant earlier. Because usually in mooting competition, we won't be knowing what are the other teams punya memorial of the claimant. So what you would do is to have this written memorial on behalf of the respondent to claimant to actually respond to the memorial that you have written for the claimant. So first you would prepare for a written memorial on behalf of claimant, and after that you will also have to prepare written memorial on behalf of the respondent. So this is very different from the usual trial or hearing when you practice later lah, because when you are practicing as a lawyer or as counsel ke for arbitration ke apa benda ke, you would only be representing one party. But for memorial submission in mooting competition, you would have to prepare both written submission for both parties, which is the claimant and also the respondent. Alright, so why is it important to write a good memorial? Why do you have to really focus on ensuring your memorial is a good memorial? There are a few reasons, but now I will be talking in the context of mooting competition per se. So first and foremost, because usually the marks allocated for memorial submission in a mooting competition is usually more than 50%. So when you go to a mooting competition, it is not about mooting in front of the judges per se, meaning to say that you are only submitting your argument orally before a judge. So that is not a mooting competition conclusively. So when it comes to mooting competition, it covers both written memorial and also oral submission. So usually in most cases, in most competitions, the marks allocated for memorial submission is actually pretty high. If it's not more than 50%, but it is actually pretty high. So it will affect your performance in the mooting competition per se, which is why you need to ensure that you are writing a good memorial so that it will increase the tendency of you to win a mooting competition. So that would be the first reason lah. And then for the second reason is that why is it important to write a good memorial is because it is easier for judges to understand your line of arguments, especially if your oral submission is bound by your written submission. Okay, so now when it comes to mooting competition, there are two types lah. Satu, mooting competition yang you punya oral submission, you are bound by your written submission. And another type of mooting competition is the competition where your oral submission is not bound by your written submission. Usually in most cases, the moot court setting punya competition, your oral submission would be bound by your written submission. But in arbitration, mooting competition, like the one that I have entered previously, our oral submission are not bound by your written submission. So it is very important to identify first whether your oral submission is bound by your written submission or not. Because when your oral submission is bound by your written submission, when you are submitting orally in front of the judges will actually ask you questions both based on both your oral submission and also your written submission. So you cannot depart from your written submission when you are submitting orally. So hence, which is why it is very important for you to write a good memorial so that the judges who would be listening to your oral submission will actually understand and get a better picture of what you are actually presenting before your judges. Because one thing that you should be very careful is because your oral submission is actually the summarized version of your written submission. So both of this written submission and oral submission are your arguments. But then written submission is much more thorough, is much more detailed, and is much more supported by a lot of case laws, statutes and whatever law resources that you would like to include in your written submission lah. And your oral submission is only a few percentage of your written submission. It's like a summarized version. So which is why your written submission is the basis, is the root core of your oral submission. So kalau you punya written submission pun is not good, if you yourself do not understand what you are writing in your written submission, so it will terribly affect your performance when you are submitting orally in front of the judges when the actual competition comes in lah. So it's basically about how to ensure that judges will follow your arguments orally. Okay, so that would be the second reason. And the third reason as to why is it important to write a good memorial is because it shows how well you know your case. Because as I mentioned earlier, your written submission is the basis of your oral submission. When you are submitting orally, it cannot actually shows how well you know your case, but if it is actually depending on your written submission. So when you write a good memorial, when you write a good written submission, it shows how well you know your case when it comes to the laws, the facts, and also the application of laws to the facts that you found in a moot problem. So here are the few reasons on the rationale and why is it important to write a good memorial and to focus on your memorial before you are submitting your case orally in front of the judges. Alright, so the contents of the memorial writing or the written submission, so it's pretty common for every kind of mooting competitions, be it the moot court punya competition or even the arbitration punya mooting competition. So first and foremost, we'll have the cover page, the table of contents, the index of authorities, statement of facts, pleadings, i.e. your arguments, and also prayers of relief. So later we will see, I will show like what where is it situated for these contents in the memorial. Alright, so entering into the body or the content of the memorial is research. The key to a good memorial is to ensure that you make a lot of research. So here, one thing that you should take into account is that when you join a mooting competition, one thing that you will keep on doing from the very moment you are selected to enter into a moot competition or you register for a moot competition up until the very last moment you are preparing to submit orally before the judges is to always research. So research is a never-ending phase. You can never stop research because every time you start your research or continue your research halfway or whatever it is, you'll always find new things, be it things or facts or laws that can benefit your client or bring detriment to your client, or the one that can be used as a shield or sword against your opponent. So which is why when you are writing a memorial, the one thing that you really cannot escape from doing is research, which means that you need to do a lot of reading from various sources. Okay. So basically today, what we are going to focus is about what to research and what are the processes that you need to take into account when it comes to good memorial writing, because memorial is very much associated with research. When we talk about, oh, I need to write a memorial, that is also equivalent to, oh, I need to do a lot of reading and a lot of research. So it is actually depending on one another. Okay, so next is how to start your research. So as I've mentioned earlier, when it comes to memorial writing, you need to do your research. And how do you start your research? How do you actually commence your research? Is there are a few steps that actually differ depending on different people will have different methods to actually do your research to write a good memorial lah. But for me, this is the things that I have always done, and I hope this can be of help. Okay, so first and foremost is to read and understand the facts in the moot problem thoroughly and also identify the area of law. Okay, so here when you have been gotten your moot problem, what is the very first thing that you need to do is to actually read the moot problem and understand the facts in the moot problem. By saying that reading the moot problem, it does not mean that you only reading it macam sekali lalu je baca, or just baca like you baca novel or baca your news dekat Twitter ke mana-mana. It's not that kind of reading. Reading and understanding the facts in the moot problem also does not take one day. okay, you would actually take a lot of times to read. You will sometimes need to read the mood problem over and over and over again. It is almost the same as research. Research is never ending phase. Reading a mood problem also is never ending, because every time you are reading your mood problem, let's say today you read dah sekali and then esok you will be reading once again. So every time you are reading your mood problem, you will discover something new. You will discover new facts that you haven't realized before, and you would also discover new information lah that will actually help to build your case. So you would have to read and understand the facts in the mood problem thoroughly. So here my tip is, because when you go for a mood competition, of course you will be working in a team, right? So when you are working in a team for this mood problem punya phase, what I would suggest is to gather all your team members in the mooting punya team and sit together, read together the mood problem and identify like the keywords that you can find in the mood problem, highlight and make sure to also search if there is any words that you don't really understand or the legal jargon yang you first time jumpa. So make sure to actually do it together in your team, because when you are reading alone, it is sometimes you are not sure whether your comprehension of that very facts is actually accurate or not. So you need to cross-check with your members. So read together with your members in the mooting team, read and make sure to read that mood problem line by line, sentences by sentences and words by words, because you need to really know your mood problem like you really need to know your mood problem like the back of your hand. Like you need to know your mood problem like how you know your Al-Quran, you know your Bible ke apa ke. So you really need to know your mood problem. If you don't know your mood problem, then it shows that you are not well aware with your case. Okay, so read and understand the facts in the mood problem over and over and over again. And also you must also identify the area of law lah. Basically when you're reading the mood problem, okay, you will see, for example, this mood problem is actually about contract law, privity of contract. Because usually when you go for a mood competition, you will actually have a general idea. Okay, so international law, like the one that you guys are holding, kan? So it is about international law. And when you go to NAMCO, Novice Arbitration Mooting Competition, it's about commercial arbitration. You will actually have the general idea. But what we are trying to say to identify the area of law is to be specific. Because we know contract law is general, but what are the substance of the contract law? We have a lot of substances in contract law, right? We have privity of contract, about valid conclusion of contract, promissory estoppel. So you need to read the mood problem to get a grasp of what is the substance of this particular area of law, so that you would know, okay, this is how to start your research. This is where you need to have your focus on your research. Okay, so first I would say how to start your research is to really master your mood problem. Okay, the next steps on how to start your research is by making the mood problem analysis. So now, after you have know the facts in your mood problem, you will have to list down the important facts that will benefit your client and facts that have the tendency to bring detriment to your client. So now when you are making your mood problem analysis on your own, usually I would do this on my personal capacity lah. Ini macam masing-masing punya own effort to ensure that you really know your case. Okay, so when you got your mood problem, for example, the mood problem punya pages actually range from one mooting competition to another mooting competition. The one that I saw, Ilsa Yuniza punya mood problem was 11 pages, right? And there are also mood competition, usually the big mood competition like VIS and also JASSEP punya mood competition. They would usually have 50 pages plus punya mood problem lah, the facts in the mood problem. So it is very impossible to baca sekali, understand sekali, then you already know your case like that, macam tu je. So what you would have to do is to make sure that you list down the chronology of the facts. Okay, for example, on 11 December 2021, what happened between the parties? And after that, on 12 December, is there any kind of occurrence that takes place? So make sure to list down the important facts lah, according to the chronological order, because you would know, okay, this is what happened, this is the dispute between the parties, so on and so forth. Okay, so that would be the first thing that I usually do. And second thing is I would list down the facts that is probably like it's a potential fact or a material fact that will be potential to actually benefit my client. So for example, in commercial law, the facts that can be beneficial for your client, for example, it says in the facts that the claimant has paid the purchase price, the full purchase price of the payment of the grapes for 1K. Okay, so that very fact shows that your client is actually have paid the full purchase price, which will be advantageous for your client. Okay, so look at that fact. And also, you should also identify the facts that have the tendency to bring detriment to your client. For example, the facts that maybe shows your client does not take extra step or precautions to deliver your goods or whatsoever. Okay, so list down the facts according to your chronological order and also facts that could be beneficial to your client. Okay, so the third step is to identify the issues and look at the keyword in the issues. So here, this is very important to start your research, because usually when you have gotten your mood problem, they would actually list down the issues yang you need to work on, because usually they will have this kind of sentence yang, okay, on the next hearing, the counsels are required to argue on 1, 2, 3, 4. So this 1, 2, 3, 4 are the issues yang you need to present, yang you need to work on. So in that issues lah, you need to find the keywords to start your research. For example, like when it comes to contract law, kan, is that the issue is about on whether there is a valid conclusion of contract between the parties. So the keyword here would be the conclusion of the contract. So then when you are entering that phrase, conclusion of contract, on the Google, on the website or whatsoever, you would have to look like, okay, what amounts to valid conclusion of contract? What are the components of the valid conclusion of contract? What is the area of law? What is the relevant case laws? What are the relevant statutes? So the issues actually is, you need to understand the issues to look at the keywords in the issues, because in the issues is the keyword where it is very beneficial for you to start your research. Okay. And then the next step is that you would have to look for relevant laws. Okay, this of course, when you start your research, you already know macam, okay, for example, this is about contract law, this is about conclusion of contract. So when it comes to conclusion of contract, how do you know like which laws, which statutes or which case laws that govern your case? Is that you would have to look for relevant laws lah. So how to look for relevant laws? I would suggest for you to actually start your research with broad finding from Google. Okay, contohnya macam you nak cari pasal conclusion of contract, right? So bila you nak cari pasal conclusion of contract, you cari dulu dekat Google. Okay, you just type dekat Google tu, okay, what amounts to a valid conclusion of contract? Okay, and then Google pun akan bagilah macam website ke, article can be like article from a lot of law firms yang write their own article about conclusion of contract, or even newspaper, or even yang study material from Sudoku tu ada, right? So you can actually start broad finding dekat situ, because it doesn't mean yang when you cari dekat Google you are going to use that sources in your written submission. This is actually for your own comprehension of your case, because you want to have a better idea or a very general idea how does the valid conclusion of contract works. So for example, after reading the websites or after reading the articles, you actually know, oh okay, the things that amount to valid conclusion of contract, actually there must be a valid offer and valid acceptance. Okay, so you actually know now lah, sekarang you dah tahu macam a valid conclusion of contract, there must be offer and there must be an acceptance. Okay, that would be for your own reading. And then now you need to support lah your reading tu. Kalau dah kata valid conclusion of contract tu ada kena offer and acceptance, what is the proof of saying that? So now in searching for the proof, you need to look for a more specific punya database. From kalau tadi kita cari kat Google je, now you kena cari yang macam academic punya database lah. For example, like Google Scholars, or I'm sure LexisNexis, Lexis Advanced Malaysia, CLJ, LawNet ke, the one yang your university have subscribed to lah. Kalau macam IIUM, we subscribe to the Lexis Advanced Malaysia and LawNet. So try to use that database yang your university has provided, and cari macam the keywords. Okay, for example macam valid conclusion of contract. Okay, what are the laws for the area of law that you are searching for, contract law kan, general article ke apa semua ke. Okay, here dekat you punya database tu, what I would suggest is kan usually diorang ada letak macam legislation, case law, article, yang usually these three are the three, and also maybe sometimes books pun ada juga. So what I would suggest for you to go first is jangan terus pergi legislation, jangan terus pergi case law, because nanti it's gonna be confusing if you do so. So start with reading journal article. Reading the article from that database first. For example, reading an article about conclusion of contract, reading an article about how to determine a valid offer, how to determine a valid acceptance. So read that article first, because when you are reading that article itself will provide you with the relevant case laws, with the relevant statutes. Because in article, they would provide the citation, footnotes, apa semua tu kan. So when you are reading words by words, sentences by sentences in that journal article, they would provide you with the citation. So and then after you baca kan, contohnya dekat journal article tu dia kata, okay, a valid conclusion of contract is comprised of a valid offer and acceptance. And then the citation number 21. So and then you look at the citation number 21 too, usually they will provide the sources from where lah they come to such finding kan. And then you, for example, it says here that section 2 Contracts Act 1950. And then you cross check with section 2. Betul ke section 2 ni cakap macam ni? And what are the things yang section 2 tu cakap? And it turns out to be memang betul pun. And in fact that section 2 has actually defined offer and also define acceptance. So from reading that journal article, you boleh extract the case law. You also boleh extract this the statute and relevant provisions in the Contract Act or any other statute yang you cari lah. Okay, so that's how you actually do your research. Mula research dengan yang besar-besar, you cari kat Google ke, buku ke, lecture notes ke apa, just go. Okay, and after that baru specific and it to be academic. And later after that, from academic tu, barulah you kena cari from the case law or statute yang you boleh extract from the journal article. So that's how the process of research I usually do, and I would encourage lah, because most of my teammates pun will usually do the same thing. We go from broad finding to a specific finding, because when you are citing your resources lah, when you write a memorial, you tak boleh lah simply ambil from which website kan. You still need to ambil yang memang legit punya primary sources like case law ataupun statute. So in order to come to that stage, there are few other stages yang would have to abide by lah to come to the finding of your relevant case laws and also your relevant statutes. And usually article memang sangat membantu because diorang letak citation and footnote. So from citation and footnotes itulah you extract what are the important relevant sources. Okay. Alright, so next, this basically are the steps lah to do your research apa semua. Okay. I think alright, so that would be for the slide. Okay, now I would like to show a little bit of the mood problem. Okay, so can I know if you guys can see I am changing my screen to the screen mood problem PDF punya?
Yes.
Okay, can you see this mood problem, e-novice arbitration mooting competition?
Yes, we can.
Okay, good. Alhamdulillah. Thank you. Okay, so now we are going to do a little bit of analysis on the steps of research that I have mentioned earlier. Okay, so this is the example of mood problem yang we did, the NAMCO one in the year 2020. So we are not going to read the whole mood problem lah, of course, but I just wanna show to you like how we identify the keywords in the issues. Okay, so this is the mood problem. When you actually obtain your mood problem, what you did is baca satu-satu ni. Okay, line by line, sentence by sentence. So see, here the consignment note also contain the following forum selection clause. So you also need to read this apa semua, like you need to really read this apa semua. Okay. And then we straight away go to the issues. Okay, alright, so issues usually at the end of the mood problem lah. Okay, so at the end of the mood problem tu usually they would have a word yang macam cakap macam ni. Okay, at the request of the director, the presiding arbitrator conferred by phone with the other two arbitrators and submitted the following hearing agenda for the October hearing. So basically, it is a word of submitting the blah 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 for the October hearing, for the blah 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 hearing. So these are the issues. Okay, A, B, C, D. Okay, usually in commercial arbitration punya moot competition, we have 4 issues. So the first 2 issues are on the procedural matters, and the third and fourth issues are the merits punya matter lah. Procedural ni it's about like determining the jurisdiction of the court or determining the jurisdiction of the tribunal to determine if they have the jurisdiction, they have the bidang kuasa lah to hear the case in the first place or not. Or another example of procedural matter would be about the locus standi of the parties, whether they actually have the right to bring the action or not, and whether a certain or particular punya laws govern or not. So that is an example of a procedural matters punya issue. While the merits for the issue C and D ni, usually merits is actually the substance, okay, the substantive law lah. Basically it's about what the actual dispute between the parties that you have to determine. Okay, basically it's about the remedies or it's about the breach and stuff like that. Okay, so let's take a look at one example here. Okay, I would choose a C because it's much clearer. Okay, so for this issue C, macam yang cakap tadi kan, bila you dah baca the mood problem and then you dah analyse the mood problem, the third steps is to look for the issues. So here is the issues. Okay, so for example, this third issue, whether the information on rerouting and the fact that rerouting is a necessity is argued by RSCL amounts to variation of the terms of the contract between the parties, and whether RSCL should have obtained the consent from CPL before proceeding with the transportation of the spices. So here, when you are actually reading this issue, you boleh dalam satu issue tu, what I usually do is pecahkan that satu issue kepada 2 sub issue. Okay, so look, and in order to do that you need to look for the connector lah yang pisahkan diorang. Contohnya dekat sini tadi I baca ada and kan. Okay, so I know from whether ni sampai the parties ni I boleh buat satu sub issue, and then after connector and ni I look for the second sentence, whether RSCL sampai transportation of the spices ni, I know I can do another 1 sub issue. So there are 2 sub issues in this issue C alone. Okay, so now let's look. So whether the information on rerouting and the fact that rerouting is a necessity is argued by RSCL amounts to variation of the terms of the contract between the parties. So here you can underline lah the issue or the keywords yang you would have to search nanti. Contohnya dekat sini, I think I will underline on the information. Okay, so here information ni nanti you carilah macam what kind of information and is that information beneficial or not. Okay, and then the next keyword is I think I can also highlight the rerouting. Okay, because you need to search for what amounts to rerouting. Is rerouting a thing or what? How does it exist? How does it work and stuff like that. And also the next keyword that I think is very important is a necessity. Okay, because why? Because nanti you kena carilah necessity ni in this context ni macam mana, because we have necessity in fact, we have also necessity in law kan. So which one applies, and also what amounts to necessity, how does necessity work, stuff like that. Okay, and then you also kena underline important thing is RSCL, which is the parties lah, because you want to know which parties are bringing this action, are raising this issue, whether it's the claimant or even the respondent. Then, okay, alright, and also the next keyword yang I think can also underline is the variation and also the terms of the contract and also between the parties. So it shows 2 parties lah. Okay, so these are among the keywords yang you can look for when you are reading the issues. Okay. Alright, and then next that we are done with the first sub issue, and then second sub issue pula, whether RSCL should have obtained the consent from CPL before proceeding with the transportation of the spices. So here again you need to underline the parties here. RSCL siapa, dia ni claimant ke respondent. Okay, after that I will also underline the obtain the consent. Okay, so you would have to search lah for how this consent works. Okay, this consent can work unilaterally or even it needs mutual consent from the parties. And after that, you also underline CPL, again the parties, to make sure which is the parties yang tengah cakap pasal benda ni. And also you can also underline proceeding and also transportation of the spices. So bila you buat research from this issue kan, contohnya one council will be doing for issue C. So nanti bila you tengok issue C tu, you cuba pecahkan dia kepada potential sub-issue. Sebab nanti when you are arguing, you are not going to argue terus satu bulk ni. You need to macam pecah-pecahkan dia supaya orang boleh faham apa isunya. Okay. So here, basically I dah boleh macam bila you buat macam tu tadi, you can actually come to a mini conclusion apa yang issue C ni actually nak. So issue C ni macam apa yang kita dah analysis tadi, kita dah analyse tadi, what I would come to a mini conclusion is that the issue basically nak cakap pasal there is a rerouting. Okay, there is a rerouting lah yang takes place here. And the rerouting here is argued by one of the parties actually is a necessity. Okay, so is this necessity actually amounts to variation of the terms of the contract ataupun tak? Okay, so that would be the first mini conclusion yang kita boleh come up for this first sub-issue. And then the second sub-issue pula dekat sini, basically it's just about consent. Whether yang before transportation of the spices ni kena consent from this CPL or not. So that is how you actually construct your draft when you are drafting a skeletal argument before you proceed with writing a memorial lah, which is to look for the issue, pecah-pecahkan mana yang boleh, cari for keywords based on that pecahan and come to a mini conclusion. What does this whole issue wants you to talk about? Okay, alright. So that would be the tips on the issue, and next I would also show the example of kejap. Kenapa? Kejap. Okay. Alright, I have actually changed my screen to a memorial. Can you guys see? I'm changing my screen.
Yes, we can.
Okay. Okay, so this is also the sample of memorial submission. Okay, also from NAMCO, the one yang punya problem ni. Okay, so as I've mentioned earlier, I would show like the contents lah of the memorial. So first and foremost, as usual, we have this cover page. Okay, usually cover page, kita akan tulislah nama competition tu and a case before who, court of international ICJ ke ataupun AIAC ke, whoever it is, and then kita akan list down the parties and also siapa parties ni, claimant ke respondent ke apa ke, and then written submission for who, claimant or respondent. So usually template ni kalau dia different lah, of course, macam ada competition yang requires this kind of susunan, ada that competition yang require different kind of susunan. So you have to abide by the rules of and also the regulations on what they want as a cover page. And usually also there are some competition yang requires you to put names of the council macam this, and most of the competitions tak require you to put your council or university's name lah, to preserve the anonymity of the parties. Okay. Alright, so next we have table of contents. So table of contents usually kita letak macam ni, table of contents, table of authorities, statement of facts, arguments. Okay, this is the arguments lah. Ada satu main argument, yang satu lagi ni AB ni would be like the sub argument, and 1, 2 ni is the point under this argument. Sebab tu saya cakap tadi, waktu part isu tadi, you tak boleh terus sekali gerabak cari dekat dalam isu tu. You kena pecah-pecahkan dulu. Sebab dia important dia dekat writing a memorial nanti. You akan tulis macam ni. Macam pecah-pecahkan dia ikut point yang apa yang sepatutnya adalah. Macam contohnya ada point yang senang untuk kita pecahkan bila that issue requires you to use a test. Okay, for example, macam proving causation kan ada yang test. I don't remember the test yang taught law 1 tu. Like you have plenty of tests kan, macam multiple action test, substantial cause. Usually that kind of issue senang untuk you pecah-pecahkan ikut test. Okay. So yeah, that's very important to pecah-pecahkan lah. Okay. Okay, since this is all about arguments, okay, last but not least, kita ada prayers for relief. Alright, so next we have the table of authorities. So table of authorities usually kita akan pecahkan ikut the sources. Okay, so kalau kita ambil treaties, convention, law, rules, guidelines, so satu bahagian. Cases and arbitral awards pun satu bahagian. And kita pecahkan lagi kalau kita ada ambil from books, journals, articles, kita pecahkan ikut satu ni. And then also commentaries and digest. Commentaries and digest ni basically biasanya from database itself lah. Dia orang ada provide commentaries. So kita pecah-pecahkan ikut macam ni. Okay, and then having done with all yang atas-atas tu, a bit of technical semua tu, and then kita akan proceed to statement of facts. Okay, statement of facts ni, what I would suggest is dalam you baca banyak-banyak statement of facts tu, I mean the facts in the mood problem tadi, bila you buat statement of facts, you kena pastikan statement of facts you ni satu page je. Kita tak nak banyak-banyak. Sebab I'm sure yang ILSA Uniza punya international law ni ada bagi tahu kan pasal limitation pages ke apa semua ke, atau ada kind of limitation. So you need to abide by it lah. Sebab nanti yang bawah-bawah ni semua kita nak dedicatekan for arguments and pleadings. Arguments and pleadings kita tu memang confirm banyak citation, banyak footnotes. So it will take space. So that is why statement of facts ni, please make sure your statement of facts is only confined to one page sahaja. Okay, sebab yang lain bawah-bawah tu biasanya memang tak cukup pun untuk kita letakkan semua yang kita dah research because of the limitations that has been provided in the rules and regulation. So my tips is, tak kisahlah banyak mana pun pages mood problem tu, statement of facts make sure satu page sahaja dah cukup. Okay, so you kena make sure lah statement of facts tu is walaupun dia very limited macam satu page je, tapi bila orang baca they already know the whole picture of what exactly is going on with the mood problem. Biasanya kalau statement of facts ni kita akan start dengan introducing the parties and also like describe a little bit the relationship between the parties. And also bagi tahulah tarik-tarik yang penting semua ni. And ini yang penting ni, macam yang I cakap tadi, buat analysis mood problem according to chronological kan. Usually dekat statement of facts kita akan extract balik facts tu according to chronological order supaya kita lagi senang untuk ringkaskan dia. Okay. Okay, so next is the arguments. Okay, part ni yang very important. Okay, tadi bila baca mood problem tadi kita identify issues kan. And identify issues tu kita tengok tadi macam ada perkataan whether, ada perkataan is there, kiranya macam word yang show question marks. Biasanya dia macam isu tu memang dalam ayat tanya lah orang panggil, okay. Tapi if you perasan dekat dalam this memorial submission, there is no like question marks. Okay, sini pun tak ada ayat tanya. Sini pun tak ada ayat tanya. Semua dia jadi ayat penyata je. Sebab apa? Sebab bila kita letak dalam argument, kiranya our arguments are the answers to our issues. So which is why tadi kita dah cari issues in question marks apa semua tu, kita convertkan dia kepada argument. And argument ni lah answer kepada issue kita. Okay? Okay, so ini untuk yang issue 1. Now I am going to show the issue 3. Yang tadi I tunjuk contoh variation semua ni. Okay. Alright. So, to come to this argument, i.e. the answers to your issues, of course you need to make your research first. Bila you dah buat your research, you dah tahu laws, you dah boleh apply the laws to your facts, only then you can come up to your argument, which is the answer to your issues. So now tadi contohlah kalau you dah cari keywords, cari issues apa semua, you cakap pasal actually from the point of view of the claimant, actually the variation yang respondent buat tadi tu is ineffective because claimant did not consent to the rerouting. Okay, so first yang 3 Roman ni, basically ini adalah answer besar kepada isu tadi lah. Macam saya cakap, bila you pecah-pecahkan tu, you boleh come up to one mini conclusion kan. Okay, so that mini conclusion you letak first answer to your issue dululah. After that baru you pecah-pecahkan ikut your sub issue tadi. Okay. So ini adalah isu yang besar yang first yang I come to a mini conclusion tadi, which is after dah cari research, I found that the variation made by respondent is ineffective as claimant did not consent to the rerouting. Okay. Okay. So bila dah cari yang isu ni, and then baru yang kita ambil yang pecah-pecah tadi tu, bawa masuk bawah dia. Contohnya macam A kan, the rerouting by respondent amounts to variation of the terms of contract. So if you remember, this A ni adalah sub-issue first yang kita dah extract from issue C tadi. Okay, and then after that, you boleh terus cakap lah arguments, you apa-apa benda. And then always remember, I'm not sure how Ilsa Yuniza punya international law punya format untuk memorial submission, tapi usually kita akan letak apa footnotes lah untuk citation apa semua tu. Ada competition yang kita kena letak macam ikut format letak citation, letak footnotes. Ada competition yang kena guna in-text citation je. So again, you need to refer to the rules and regulations, but here is a general idea about how I'm going to show the flow of how to extract from issues kepada argument. So, kena transfer issue kepada argument. Okay. Alright. So, dah cakap-cakap apa semua, and then turns out to be you ada lagi point-point nak cakap yang you rasa macam perlu a bit detail. So, you letak bawah this sub-issue ni, kiranya points, supporting points for your issue. Macam contoh nak bagi tahu yang variation by respondent ni is ineffective kan. Boleh bagi tahu if ineffective kan. Kenapa ineffective? Sebab ada unilateral variation. Okay, and then provide lah the laws and also the case law. Jangan lupa apa semua artikel ke yang you dapat cari apa semua. Okay, and then lepas tu pun you discover lagi, ada lagi benda nak kena cakap yang a bit different from point 1 tapi still would contribute to your whole issue kan. Okay, cakap lah silence pula, it's not an acceptance towards rerouting. Okay. Okay, so tu untuk isu sub-issue 1 yang I cakap tadi. And then untuk sub-issue 2 pula, kalau you remember the sub-issue 2 yang kita extract from issue C tadi, which is about consent. Okay, so here is the conclusion that I came up after I research on sub-issue 2 tu, which about respondent should negotiate to seek consent from claimant instead of rerouting. So here, I pun cakap lah pasal argument ni sebab tadi I dah cari kan, yang pasal rerouting ni, kalau you ingat tadi, isu tadi dia cakap pasal whether yang one of the parties tu kena seek consent from another parties kan. And then after I dah research, I came up to a conclusion, memang kena dapatkan consent dulu. Tak boleh suka-suka hati proceed with the transportation of the spices. So here is my answer to that issue. Okay, and then I pun bagi tahulah kenapa duk panjang-panjang ni semua apa semua. Okay, and then done. Kalau I tak ada lagi apa-apa supporting points macam yang isu A tadi, then I tak payahlah tulis. Sebab basically benda sama je ke, benda berulang ke, so terus masukkan sekali. Ini memang dia punya ada limit word count 2,500 pages for this memorial. So which is why kalau you nampak dia macam sikit kan dia punya argument dia. Kalau ada other competitions macam Vismut especially memang tak ada limitation, yang itu memang sampai orang ada 70 pages, 50 pages plus diorang write memorial submission sahaja. Kalau yang ni 20 pages je. So you need to refer to your rules and regulations lah according to the limitation of word counts, limitation of word pages ke apa semua ke. So it depends on that as well jugalah in the process of writing your memorial. So that is how you actually write your memorial lah. Okay, so first baca mood problem, fahamkan betul-betul, buat your own analysis of the mood problem, chronological order, apa facts yang material, siapa parties yang involved, apa relationship between the parties, apa dispute between the parties, and then parties ni nak pergi mana, after that nak bawa ke ICJ ke atau nak buat settlement luar mahkamah ke, and if diorang dah pernah ada relationship between this, okay, ataupun if they are bound by any laws ke apa semua ke. So you need to identify that in your mood problem punya case lah. And after that, bila you start research tu, macam yang cakap tadi, research according to issues. Okay, you gonna research tu according to issues. Facts tu untuk support you punya argument nanti. So dekat issues lah you kena pandai, you kena always main dengan keywords lah dekat issues tu. Sebab kadang-kadang issues tu dia guna perkataan ni,
Tapi dekat dalam law dia tak guna perkataan tu, dia guna perkataan lain. Tapi both of these perkataan actually have similar meanings. So you kena cari sinonim ke, antonym ke. So you kena like play with words, play with keywords and always try to look for alternative of that words yang kadang-kadang can bring different meaning as well lah. Okay, untuk ensure whether that is the correct word. Macam contoh, consideration. So consideration in law yang kita belajar dalam contract law and consideration yang we dalam layman punya language kan berbeza kan. Kalau consideration dekat dalam contract law means like price, money, something that you give in return lah for your purchase or anything. Itu untuk contract law. Kalau consideration yang biasa macam yang biasa-biasa kita guna macam it amounts to consideration like take into account ke apa semua ke. So you need to make sure in that context of that mood problem which word yang sebenarnya guna. Adakah consideration in contract law atau consideration yang biasa-biasa dalam layman term. So it is very important to be creative when it comes to research. Play with keywords, play with words and then itu untuk basically for issues lah. Okay, and after that bila you dah dapat keywords apa semua tu, you dah boleh macam connect the dots. Oh, this is actually under contract law, under valid conclusion of contract. Or kalau international law, pasal dispute between the parties ke apa semua ke kan. Okay, so you dah dapat gambaran tu, barulah you start cari dekat database yang mana-mana. Okay, buat macam saya cakap tadi, start broad dulu, cari dekat Google ke, lecture notes ke, lecture materials ke, suka hati you nak cari mana. Okay, tapi kena ingat benda tu tak boleh jadi sources in your memorial writing. It can only be your first step to comprehend the facts or the research that you will be doing lah. Okay, lepas dah cari besar dekat apa Google apa semua tu, baru you spesifikkan dia dekat academic punya database. Okay, contohnya macam kalau you subscribe to Lexis Advanced Malaysia, you cari dulu artikel, journal artikel. Dekat artikel tu baca and then tengok dekat apa citation dia, tengok dekat footnote dia and then only then you extract you punya case law, you extract the statute. Sebab nanti yang akan jadi you punya sources tu bukannya yang apa tu, bukan yang you baca-baca dekat database ke, you baca-baca kat website tu, tapi case law and statute tu. Tapi to come to that process, ada proses lagi yang you need to abide by lah. Okay, and you dah cari apa semua tu, kiranya lepas you dah cari tu mestilah you know kan your apa dalam law ni boleh ke tak ada variation. Dalam law ni kalau ada variation ni maksudnya kena ada consent from the parties ke tak kan. So lepas you cari isu tu, you dah came to a mini conclusion, then you buat argument. That argument is the answer to your issues. So kalau you follow this step one step at a time lah, I would say. Okay, take your time to do your research. Lepas tu pula lagi research ni macam I cakap tadi, dia never ending punya proses. Okay, so you always need to do your research. Tapi it can be a bit stressful lah when it comes to research. Sebab kadang-kadang macam research ni dia bukannya satu proses yang linear je naik. Macam okay hari ni dah ada progress, esok progress, esok progress dah lengkap apa semua, tak. Memang tak. Research ni satu proses yang ada atas kejap, bawah kejap. Kadang-kadang macam monotonous, dia tak jumpa apa-apa. Kadang-kadang you jumpa banyak benda. Kadang-kadang tak jumpa apa terus for a period of time. So you kena macam cari masa sikit lah, macam just allocate macam okay hari ni nak buat like research on this issue like for 1 hour pagi, 1 hour petang macam tu ke apa semua. Like you tak boleh macam terus menerus ke apa semua sebab it's not going to be productive lah, because aside from research for mood problem, you mesti ada academic commitment yang you need to cater to, and also macam you nak keluar ke apa semua ke. So you macam kena tahu pandai masa sebab research phase ni can be as stressful as the phase for you to prepare for your oral submission. And in fact, sometimes lagi stressful sebab you tak ada progress apa semua. So it is normal, but it's okay. It's part of the process of learning. Okay. And then another thing yang I would also share is that, I unshare dulu. Okay. Okay. So another thing yang I would like to give my tips is that when it comes to research and also do your memorial writing, you kena always ask around your team members lah, okay, whether they understand your point ke tak. And kadang-kadang one facts about research, one facts about memorial writing is that kalau you rasa apa yang you tulis tu betul, actually tak betul pun, sebab you sendiri yang baca. So you tak boleh confine you je yang baca, you kena try seek help from other people yang bukan your team members to actually baca your submission. Faham ke tak? Faham ke the flow? Nampak tak dia punya correlation apa semua? So try to seek help from seniors, lecturers to actually cross check lah whatever written submission yang you dah tulis tu. Because trust me, kalau you rasa betul, benda tak betul sebenarnya. Yeah, I've been there a lot of times. Kita je perasan macam bagus je aku punya ni kan. Tapi sebenarnya tak pun. Okay. Because it's different from assignment lah kan. Sebab macam assignment tu dah confine, satu benda je kita kena cari. But then research untuk moting ni dia tak confine, dia ada banyak. Kalau you rasa macam ni, tiba-tiba opponent you bawa benda lain kan. So you can always be prepared with every possibility that will come and attack you. Especially when it comes to counterparty. So my final tips is that I hope yang I wish all the best lah untuk the one yang will participate in the Ilsa Yunisa punya International Law Moot Court competition. I baca sikit-sikit dia punya moot problem. It's very interesting. That's why I myself tak pernah buat international law. So I'm not sure like how can it will work. But I'm very sure it's going to be interesting lah if you have the passion and also know how to be creative. So research ni it's all about be creative lah. As much as you need to be creative when you are submitting orally, because you nak kena cari jawapan and judges ni tanya macam ni, oh you nak jawab macam mana, ataupun you sebenarnya tak tahu pun jawapan tu tapi you tak boleh lah buat tak tahu kan. So you kena be creative. So as much as you need to be creative for your oral submission, you need to be creative for your written submission juga. You kena be creative tu maksudnya be creative macam saya cakap tadi when it comes to research, you kena be creative with the keywords that you want to utilize. And also you kena be creative with cara nak susun your issue. You also kena be creative with macam mana nak susun your punya argument. Sebab you tak boleh jawab isu tu satu gerabak terus. You kena pecahkan dia for the sake of writing a good memorial. Yeah, I think that would be it from me. I think I'll pass back to Sister Faridatul.
Okay, thank you to Ms. Shahmina for your presentation. Now we will open the Q&A session for Ms. Shahmina. Everyone is welcome to ask anything regarding the memorial submission. Feel free to open your mic or write down your curiosity in the chat box.
Hello, sister. Am I audible?
Yes, you are. Hello.
Hi, good morning. I have a question regarding about the footnote. Is there any way that make me and my partner's task easier in doing footnote? Is there any platform that you use, or do you use just a Word file and then transfer to one another?
Oh, okay. Thank you for the question, Martin Luke. Okay, so for footnotes, usually when you are researching kan, when you research to itself, you need to prepare the sources of your the reading materials. For example, let's say a journal article, okay, a journal article about conclusion of contract. So after you read that journal article, you find that, oh, okay, this part of this journal article is important, okay, and then you do like a Google Docs lah, okay, you do a Google Docs, you paste the part where you want for that journal article, okay, paste in the table, and then you tulis siap-siap, you terus tulis like the citation of that journal article, okay, and after that just paste je dekat your memorial using kalau you buat dekat Google Docs kan ada yang machine for footnote tu kan. So tengoklah kalau you nak CMS ke APA ke, so just masuk kan, and then it will automatically generate for you. So then just paste in your memorial submission. So the key here is waktu research tu you need to do the citation already, because when you research, there is always a high tendency for you to lose your reading materials, to lose your research. So we don't want it to happen, because nanti you need to cari balik, sometimes you dah terhilang mana, dah terdelete, refresh ke apa semua. So research, then write citation. Research, write citation, simpan. Bila you dah start tulis memorial, then just tukar macam biasa, just paste balik that citation dekat dalam machine for footnote tu, generate it and then paste. That's basically how I do lah. Kalau in terms of convenient tu, I would say it's pretty much the same when you do assignment and write a memorial for mooting competition, the footnotes. But it's just a matter of to put you into a convenient state, is to make sure as early as the research phase, you need to prepare the citation of your reading materials as well. So that would be how I think would help lah. Am I answering you, Martin?
Yes. Crystal clear. Thank you so much.
Alright. Okay.
I have another question. In memorial, application is important ke? Ke just put the facts only?
Okay. In memorial, application is the utmost important. Okay. So there is like a slight difference now when you are writing the IRAC for assignment or answering question for law exams ke apa semua, and also writing a memorial. Kalau dekat IRAC, we usually will focus on the rules. Banyak kan kita akan letak, okay, section 2 Contracts Act, this case law, that case law. So usually in your essay tu, usually lah when it comes to law student, your essay parts will be longer than your application parts, okay? But that is different when it comes to memorial writing. In memorial writing, of course, rules, the laws, the case law and statutes is important as well. But then we focus more on the application. So when you write your written memorial nanti, you punya application tu is the substantial part of your argument. Yang rules semua tu dah tak ada dalam paragraph dah. Rules semua tu masukkan dekat dalam footnotes apa semua. So basically, your paragraphs in your memorial submission is all about application. The rules is all about footnotes apa semua. So it's the difference between writing IRAC and also writing a memorial submission is the part when you apply. So sekarang macam you tak payahlah dah nak mention the rules balik ke the facts ke apa ke, terus apply. So kalau that's why lah macam lepas you research, you terus tengok facts apa-apa semua, fahamkan betul facts and then terus apply. That's how you write written memorial. So what I can conclude from my answer to your question, Martin, is that application, yes, it is very important. It actually forms the core of your memorial submission. Am I answering you?
Yeah, certainly. Thank you so much.
All right.
There are other two questions in the chat box. First from Dania Batisha. What are some of the best websites to find relevant laws? And the second one is from Nurul Hawa. What are some of the mistakes that you've learned from writing memorials before that people should avoid doing it?
Oh, okay, interesting question. Okay, what is the best website for relevant laws ni? Okay, website untuk cari relevant laws ni, I would say it depends on the type of moot competition that you go for. Okay, for example, if for me lah kan, kalau yang usually I did is international commercial arbitration, the VISMOOT and also the NAMCO. So for this type of mooting competition, we actually have our own database of research. It's called the CISG. I think it's Convention on International Law, International Sale and Goods Law for United Nation country or something like that lah. Okay, we have that database. So basically our research is confined to reading a website from Google for our own comprehension and also searching laws from that website. Sebab dekat dalam that website, they have already provided you with books, journals, case laws, annotated legislation, commentaries, digests and stuff. So we just need to cari keyword dekat dalam moot problem and cari relevant law. So it's very convenient lah for that type of mooting competition. So, if international law, I think there are also macam website or database untuk cari that relevant law, because as I have heard from my friends yang join JASERP, they are actually using a particular website juga. So I'm not sure lah whether that website is accessible, is also applicable to international law this area juga ke tak, sebab international law kan is pretty broad kan. So I think maybe you can try to search around, play dekat Google tu, cuba main-main dengan ayat ke apa ke website yang boleh lead you to cari relevant laws. Because kalau I nak bagi tahu like specific apa website pun tak boleh juga, sebab dia different tau. Kalau macam yang I masuk dah ada database, ada certain yang memang tak ada database, so you kena cari sendiri macam dekat mana-mana website ataupun academic punya database yang can actually help lah. For example macam SAMCO, kita tak ada database macam NAMCO tu, commercial arbitration, it's sport law punya database tu memang tak ada. So basically kita just cari macam rules yang they have provided in the moot problem lah, and then kita just tengok ada tak case law ataupun annotated legislation. So what I would suggest, the website relevant tu yang you can actually do is try to maybe ask around or check dekat Google if there is any website for research for that particular area of law yang you are trying for. Contohnya macam international law kan, maybe try cari dekat Google website research for international law or international law websites or whatever. Try lah. I think there is plenty. It's just that I'm not sure which one lah, sebab I pun tak pernah masuk international law. So I am sorry sebab tak boleh bagi exact. So I can just macam bagi you idea untuk cari dekat Google, try to search around lah for that thing. Okay, that is for the first question. And second question about mistakes. Okay, mistakes yang I learned is that bila you are writing your memorial submission, memorial writing, you kena tukar mentality you. You tak boleh write macam seorang law student. When you are writing a memorial, you are not a law student. You are a counsel. You are a lawyer. You are an agent to your client. Which is why you tak boleh guna ayat macam to apply. Ataupun like for example, biasanya macam ayat law student kan, bila kita dah list down rules apa semua tu, kita akan usually guna ayat yang macam in relation to this case, in conjunction with this case, in the current case, ataupun to apply the relevant laws. So don't use that words. Okay, that is words for law student. You are not a law student when you're writing a memorial submission. You are a counsel. So terus just straight away. So macam terus kata, so respondent in this case has breached the contract by virtue of Article 79 of the CISG or Article 79 of the Contracts Act 1950 because they failed to honour their obligation in the contracts. And then you bagi tahu the reason. So make sure when you are writing your memorial, you tak terbawa-bawa IRAC punya structure of ayat. Of course, when you are writing your memory, you need to have IRAC as well. You can ada issue, you can ada rules, you kena ada application, and you kena ada conclusion. That is very important. Memang kena ada IRAC dalam memorial submission. It's just that the structure of your words tu, you are no longer as if you are writing or answering your exam question in memorial submission. So issue you tu, kalau dalam IRAC dia jadi weather kan. Kalau dalam memorial submission tak ada weather ni semua. You straight away terus ambil yang argument, which is the answer to your issue. So your issue in your memorial submission is not an issue with question mark, but it is an answer to your issue. That makes up your issue in written submission. And also the rules yang macam I mentioned tadi, you tak payah dah nak cakap, according to the case of according to the case of Carlyle Carbolic tu, contract tu, Carlyle Carbolic or something, don't remember dah, lama dah. According to that case, the principle is that blah blah blah. No, tak payah nak sebut tak payah nak sebut the facts of that case, tak payah nak sebut the principle apa semua. You terus straight away apply dekat you punya facts tu. Contohnya macam I mention tadi kan, about the parties who have not breached the contract. The party okay, contohnya respondent has breached the contract because they failed to honour the obligation in clause 7 of the sale and purchase agreement, contohlah. And then bagi tahu apa dia punya breach tu. And then footnote kan you punya principle from that case. So kira kalau principle from that case cakap pasal okay, yang akan amount to breach of contract is non-payment of purchase price. And exactly in your facts ada cakap pasal that counterparty has committed a non-payment, then you just footnote kan je dekat that dekat that facts. Okay, so tak payah lagi nak cakap pasal case facts, apa case yang you refer to the facts ke the principle ke apa semua. It's IRAC. IRAC untuk apa jawab law question boleh lah, tapi untuk yang ni tak payah sebab first kita ada limitation on number of pages, and secondly because the rules tu actually kalau judges yang baca, they already know the rules. Most of the judges, they already know the rules. Oh okay, kita akan pakai ni, kita akan pakai ni. So diorang tak nak tengok rules tu sangat. Diorang nak tengok how that rules you will apply to your case to help your client. So my mistakes in the past, I think this is usually everyone pun will have the same mistakes lah when they are writing memorial for the first time ke atau baru-baru ke, is to use the same to use the same structure sentence for IRAC in your law paper and also in memorial submission. So it's still, as I mentioned earlier, you don't depart from IRAC 100%. You still use IRAC tapi sentence structure tu kena tukar. Tak payah nak guna to apply. Straight away, straight, precise, concise, short and sweet and simple. That would be how it differs from writing or answering a law exam and also writing a memorial submission. Yeah, that would answer the second question. I hope I answered these two questions. Is there anything else?
There another question from the chat box. Norzain Patel wondering if you have any example for the prayer for relief. And the second question is prayer for relief is the same as conclusion?
Oh, okay. Prayer of relief. I lupa nak tunjuk tadi. Yeah, prayer of relief, dia... Okay, kejap ya. I think I can share balik. Screen. Alright, can you guys see my screen is changing now?
Yes, we can.
Okay. Okay, nampak tak prayers for relief ni?
Nampak?
Alright. Okay, so now prayers for relief. Okay, so nampak tak 1, 2, 3, 4. Prayers for relief ni nak kata dia conclusion. Dia memang conclusion tapi dia basically what statement yang kita minta from the court. Okay, itu satu. It can be statement yang kita minta from the court, or secondly, it can also be the answer to our issues tu. Contohnya macam tadi yang number 3 ni kan. Okay, prayers for relief is the variation was ineffective as claimant did not consent to the rerouting. So basically prayers for relief is actually the answer to your argument tadi. Okay, itu satu boleh jadi yang tu, ataupun satu lagi you boleh juga buat prayers for relief you tu macam apa yang you minta from the court. Sebab prayers for relief ni it means yang what we are seeking from the court. Contohnya kita macam minta court untuk ketepikan the jurisdiction, ataupun kita minta from the tribunal yang bagi tahu okay, tribunal has jurisdiction to resolve this dispute, so you can hear the dispute. So kita minta from the, basically a statement yang you minta from the court apa for your client. Kalau macam nombor 1 ni kan, okay, the tribunal has jurisdiction to resolve this dispute. So maksudnya dekat sini kita minta from the tribunal untuk bagi announce ataupun untuk give order yang this tribunal ada jurisdiction to resolve this dispute. Tu first. And second pula kita minta yang tribunal ni allow Dr. Iron Lee to be an expert witness. And then thirdly, kita juga minta the tribunal untuk order yang the variation ni was ineffective as claimant did not consent to the rerouting. And last but not least, kita minta from the tribunal untuk order yang spices are non-confirming and respondent is liable for fundamental breach of contract. So the important thing to take note is that prayers for relief is actually the things that we seek from the tribunal or from the court for our client dengan cara kita answer our issues tu. So that is basically the example for praise for relief and what I could say about praise for relief lah. Can I know if I'm answering your question? I hope that I answer your question.
Yes, thank you so much.
Alright, thank you. Is there anything else? Question lagi?
Are there any other questions? Seems like there are no other questions, so I will proceed now. Thank you to Ms. Shamina for tips and tricks, and thank you for the questions to everyone who attend, especially the oralists. We sincerely hope that this session has helped you to at least get an idea of what to research. Oh, there are some other questions. Do you have any tips or tricks on how to manage to join and win some of the moods competition?
Okay, tips to join mood competition. It's pretty broad punya question, so I think I'll just say in my context lah. Okay, when I join a mood competition, first and foremost, I would say yang I am crazy for mood competition. I don't know why I'm so passionate about mood things, but I start mooting from my first semester, and sekarang I dah third year, second semester, I still haven't stopped mooting. And I think my final year pun rasa macam nak masuk lagi. So I don't know, I'm so crazy about mooting. So it's been my passion lah. So I think first and foremost you need to discover your passion. Whether you memang masuk memang untuk betul-betul you suka mooting, you nak try something, ataupun you masuk just macam kawan suruh masuk ke, atau just nak cantikkan your CV ke apa semua ke. So kalau it's the latter tu, macam just nak cantikkan CV ke atau kawan suruh masuk ke, still boleh lah actually, sebab nanti nak discover your passion ni bukannya senang kan. Macam you tak boleh nak kata, oh I think hari ni I suka mooting, nanti esok ke tiba-tiba you dah tak suka mooting kan. So passion ni it's actually a long process to discover. Boleh je, cumanya it's a bit hard lah kalau you tak cari, tak try in the first place. So my tips when to join mood competition is try to first find your passion, whether you like it or not. And second, kalau I akan tengok the area of law for that particular mood competition after my second, third apa semua. Sebab first timer kan, waktu I try tu, I tak tahu pun. I try first tu dah international commercial arbitration. Waktu tu I baru first year and I was like, what is this international commercial arbitration? Tak tahu apa kan. So bila after that, bila dah dapat knowledge apa semua, dah ask around, try to macam search sikit, okay what is international commercial arbitration, and all after that, bila my second, third mood competition tu, I try tengok the area of law for that mood competition lah. So dekat dalam mood competition, ada banyak area of law. Okay, contohnya kita ada international humanitarian law. Okay, international human right. Kita juga ada international law, the one yang you guys are doing right now. Kita juga ada international commercial arbitration. Kita juga ada constitutional law. Kita juga ada sports law. Okay, and then lagi satu ada contract, company, commercial and stuff. So there are a lot of area of law in mood competition lah. So you first kena tanya diri dulu lah whether you suka apa area of law. Kalau I suka commercial. So sebab tu I memang buat commercial je dari first year sampai third year, memang I masuk international commercial arbitration. Dah specific arbitration. I tak suka buat moot court setting. Sebab kalau moot court kan, kalau you submit your evidence ke, case law ke apa semua ke, you are bound by the binding precedent tau. Kalau arbitration, you tak bound by any binding precedent. Sebab semua case law or statute yang you bawa tu, kalau arbitration semua persuasive. Tapi kalau moot court, you kena bound by the binding precedent. So I tak suka sangat binding ni. I just suka freedom tu kan. So yeah, I am more prone to that area of law, commercial. So kalau you suka contohnya macam constitutional law kan. Kalau you suka constitutional law, you tengoklah. Kadang-kadang dia orang akan buka registration dah for KL Bar Moot Competition, and so Tun Sufyan Constitutional Law Moot Court Competition. So you need to rajin tengok the IG of your moot club lah, IG of moot club ke, UNISA ke apa semua ke, sebab usually these organisers memang akan buka secara terbuka ataupun dia akan hantar email. So your institution yang akan manage that competition for you lah. So you tengok you suka area of mana and then you try. Lepas tu another thing yang I would give tips is that make sure bila you masuk that mood competition tu you give your full commitment lah. And then you give your full commitment tu bukanlah maksud you focus mooting je 101% that you forget you have any other academic commitment kan. So you need to always pandai manage masa lah. Contohnya macam saya cakap tadi nak buat research kan. Macam mooting ni like 80% of your participation in a particular mood competition actually makes up research. Okay. So dia macam nak present depan judges tu 10 minit, 20 minit macam tu je. Research tu kadang-kadang sampai berbulan-bulan. Kalau you masuk big punya mood competition macam this mood punya, it takes 7 months of preparation tau. So 7 months tu, 7 bulan tu memang you kena buat research. Memang nak muntah lah buat research tu semua. So you macam kena pandai manage time and also manage your stress. But as I mentioned earlier, mooting is stressful. But it's gonna be fun if you can actually try to embrace lah the environment waktu mooting. Sebab kalau waktu I mooting, the best part of mooting is be with your teammate. Sebab kalau big mood competition kan, diorang ada bigger team composition tau. Maksudnya macam dia ada banyak team members. Kalau macam Ilsa Yuniza international law ni, I think it's 2 councils, 2 members per team lah. Kalau macam this mood yang I entered, we have like 8 members. So the best part of being in a mood competition is of course the research with my team members lah sebab ramai. So we spend time together for a very long time. So try to find the fun in mooting. Contohnya macam the fun in mooting is usually among you punya team members lah. Okay, try to do activities with your team members, bonding apa semua. Because every mooters would definitely say the same thing. Mooting is stressful. Mooting is stress. Okay, mooting tu equivalent to stress. You tak boleh lari daripada rasa stress. Cuma it's a matter of how to turn that stress into something yang you find fun in it. Which is why to make sure that you are being passionate about mooting, you like what you are doing, and of course to share that joy of being in a mooting team with your other team members. So yeah, that will be my tips. It's about finding your passion, try to discover your interests in area of law, and also try to make memories with your team members throughout this mooting competition. Yeah, I hope that answers your question.
Thank you to Ms. Shamina for the tips and tricks, and thank you for the questions to everyone who attend, especially the oralists. We sincerely hope that this session has helped you at least get an idea of what to research in your memorial submission for our upcoming competition. Here's a friendly reminder. I would like to again remind all participants to fill in the attendance form, especially to those who had not yet filled in the form yet. This is the end of our workshop too. It'd be an honor if everyone can open your camera for our photo session. Let's treasure the memory together.
Okay, I will be taking the picture. Is everyone ready? Okay, 1, 2, 3. Okay, done. Thank you.
Thank you. Bye.
Thank you, Ms. Shamina.
Thank you, Miss Shamina.
Thank you, Miss Amina.
Thank you and best of luck.
Thank you semua.